Go ahead. Proceed.
Hello,
You can proceed. Yes, you can proceed.
Okay, thank you. Thank you very much, Chairperson. The next case, Chair, is about Mr. Tamaga, who voluntarily, I think we dealt with that one. Next matter, Chairperson, is about Mr. Khachara. Mr. Khachara was dismissed on the 17th of December 2015 for absenteeism. The official was subjected to a formal disciplinary inquiry, and a sanction of dismissal was meted out by the inquiry. The official appealed the sanction. He then lodged an unfair dismissal dispute with the GPSSBC. The arbitration award was in favor of Mr. Khachara. The department took the award on review because of the seriousness of the act of the misconduct, and the matter is still pending at the Labour Court. The next matter is of Mr. Masango and Mr. Kosana. Mr. Masango and Kosana were dismissed on the 3rd of June 2016 for incitement and threatening management with violence during a feedback briefing commissioner of Gauteng. The officials were subjected to a formal disciplinary inquiry, and they were found guilty and subsequently dismissed from the department. The officials appealed the sanction, and the appeal was dismissed. They then lodged an unfair dismissal dispute with the GPSSBC. The arbitration ruled in favor of the respondent, namely the department. The officials took the arbitration award on review due to the seriousness of the act of the misconduct. The matter is still pending in the Labour Court. And subsequently dismissed from the department. The officials appealed the sanction. Chairperson is about Mr. Malisweni AS. Mr. Malisweni was dismissed on the 24th of January 2017 for absenteeism and absconding. The official was subjected to a formal disciplinary inquiry which meted out a sanction. The official appealed the sanction, and the appeal authority upheld the sanction of dismissal. The official did not refer the matter externally for dispute resolution. The matter is considered dismissed on the 24th of January 2017. The next one, Chairperson, is about Mr. Semate JB, and others. The officials were dismissed on the 28th of September 2017 for participation in an illegal strike at Johannesburg Management Area. Mr. Smartley was the instigator and the team leader of the unprotected strike action. The matter is currently at arbitration level at the GPSSBC chambers. The incident between the two SMS members in the Western Cape Regional Office, Chairperson, was also one. DCS can indeed confirm that there was an incident between the two SMS members in the regional office of Western Cape. The matter was investigated initially internally by a deputy commissioner who in a preliminary report recommended that the matter be investigated further. An external advocate from Cape Town was appointed to investigate the matter, and the report was recently received. The recommendations are currently under consideration, Chairperson, but it may be indicated at this point that the findings put a blame on both SMS members. It can further be mentioned that both SMS officials opened criminal cases against each other at Goodwood SAPS, but the senior prosecutor on the 23rd of August 2019 declined to prosecute, citing the following: no reasonable prospects for a successful prosecution. In summary, Chairperson, we need to point out that out of a total of 11 cases which were reported of alleged abuse of power, 8 disciplinary hearings were taken on review externally by the concerned officials. No referral was made for the 3 cases. Furthermore, the 6 cases are at Labour Court, of which 1 is finalized and in favor of the department, and 5 are still pending. Lastly, Chairperson, 2 cases were referred to the GPSSBC, of which one is finalized in favor of the official and another one pending at arbitration. In conclusion, Chairperson, we need to indicate that the very nature of the correctional system requires a strict code of behavior, which is supported by a clear and effectively enforced disciplinary code with effective disciplinary procedures. The disciplinary code and procedure of the department is consistent with the principles of administrative justice, while at the same time ensuring effective and timeous action in instances where the safety, security, and orderly management of correctional institutions is at stake. Discipline is a core supervisory and management responsibility, while particular procedures may be in place for more serious offense that results in special investigations. Officials of the Department of Correctional Services are continuously exposed to training and awareness campaigns. The department is handling the labor disputes in accordance with the Constitution and the Labor Relations Act 66 of 1995 as amended. Therefore, officials are encouraged to utilize dispute resolution forums, which are promulgated in the Labor Relations Act. Furthermore, Chairperson, the Department of Correctional Services and Recognized Labor have signed a collective agreement, GPSSBC Resolution 1 of 2006, about the disciplinary code in the department. The objective of this code and procedures is to regulate the behavior of and promote mutual respect between employees and an employer, and to ensure that managers and employees share a common understanding of misconduct and discipline. Furthermore, Chairperson, DCS members are exposed to different training programs that are aimed at promoting acceptable conduct, provide employees and employer with a quick and easy reference for the application of discipline in order to prevent arbitrary or discriminatory actions by managers towards employees. That's abuse of power. And moreover, Chairperson, the aforementioned correctional officials have acted in a manner that is inconsistent with professional duties and obligations of the department, in that their acts have put the name of the department into disrepute. All the reported cases, Chairperson, on alleged abuse of power have been proven on a balance of probability that the department had acted correctly in all of them. The alleged abuse of power cannot be proven or be detected in all these reported cases. Most of the cases were appealed, but such appeals were dismissed, and the final dismissal outcome have been maintained throughout. Lastly, Chairperson, the allegation of abuse of power leveled against the department could not be found in all these reported cases, which were handled by external independent arbiters and not by the officials of the Department of Correctional Services per se. With that, Chairperson, I want to thank you for this opportunity to present this state of affairs to the committee. Thank you, Chair.
Thank you very much for that presentation. You stayed on time, less than 20 minutes, which is good because the presentation itself is short. Thank you for that. Colleagues, because we have 2 presentations from different departments, I'm going to ask that we deal with this one first and put it away, and then we'll follow with the other one. I have the following speaking list. I will start with Honorable Horn, given his apology to attend the funeral, so that he gets his issues on board and be ready for that. He will be followed by Honorable Steve Swartz, followed by Honorable Maseko Jele, followed by Honorable James South, followed by Honorable Msimang, followed by Honorable Breitenbach, and Valma Newvold. That is the lineup for the questions. Honorable Horn, it's your opportunity.
Thank you, Chair. I think in terms of performing oversight on the department in respect of this issue, what would be helpful is if we could also get the following information from the department. The total number of disciplinary hearings they typically undertake in a financial year, the typical turnaround time for finalizing an investigation and a disciplinary hearing from the time there is a complaint, what criteria they used in order to determine whether an official is suspended pending an investigation and or a hearing, and what the typical or average period is for which both junior officials and then more senior officials who are suspended are on paid suspension pending an investigation and a disciplinary hearing. Ultimately, I think if in order for us to evaluate the real effectiveness of the disciplinary system, I think we will be in need of this information as well. Thank you.
Thank you, Honorable Horn. You know, as we always do, I'm going to ask the department to immediately respond to that, because I want to avoid any leakage of responses. I think we have established this practice now. National Commission and your team, can I get responses to those 4 issues raised by Honorable Horn before I proceed to the next member?
Thank you, Chairperson. Maybe on these, if we are allowed to give it in writing, for some of the information, Chairperson, is available in the annual report, but based on the detail of the question by Honorable, we'd be able to make that information immediately.
Commissioner Fraser?
With that,
we can't hear you. There's a lot of echo there. Please reposition and respond again. I hear a bit of what you're saying in terms of forwarding written questions. Can you repeat that? But we couldn't hear you properly.
Thank you, Chair. Can you hear me now, Chair?
That's much better. Thank you very much, Commissioner.
Thank you, Chair. No, I was indicating that this information is available, but not necessarily on hand now, Chairperson. Some of it is, resides in the annual report, but we can prepare and submit within the week to the Portfolio Committee. Thank you, Chair.
Fine, because all of them are very detailed and need that information, so you can forward that in writing. Thank you. I hope that helps Honorable Horn. Let me go to Honorable Swartz.
Thank you, Chair. And just very briefly, I'm grateful for this very extensive presentation that has been given on each one of these matters. I'm just trying to appreciate our oversight function that we exercise. We need to obviously look very carefully at these matters, but given the environment of correctional services, it is very clear that, largely speaking, due process is followed when one looks at the fact that there's, and of course, I'd also like to look at the further information, the time that has been requested by Mr. Horn. But it does seem that there's been disciplinary hearing, internal appeal, then a further unfair dismissal disputes lodged with the General Public Sectoral Bargaining Council. And then, of course, the important aspect that comes in is a number of these cases went to external review. 8 cases went on review to the labor courts. Now, that brings in the judiciary. So we've got to be very sensitive to what degree we can exercise oversight where there is an external judiciary involved as well. I'm not saying we can't, I'm just saying we need to be sensitive. But in generally speaking, I am relatively satisfied with the explanations that have been given so far. And I would look forward to just hearing the matters that are still pending. When is it envisaged that they would be finalized? And I think that would help us to conclude our issues. And it's not easy. Again, we might need a written response to that for the matters that are still pending, and that would assist us as well. Thank you.
Thank you, Chairperson. Chairperson, I'm not sure if I'm allowed to raise one thing before we go on with the report, because I was cut earlier. I was cut. So it's only one issue about the apologies that we have received, Chairperson. I'm afraid that the colleagues, or in our last meeting, we were not able to process one report that came because of the numbers of the colleagues who left and those who apologized. But now the very colleagues that we were together in the last meeting, if, like, for example, Honorable Horn requested to go early, and then also one of I don't know whether it's Honorable Swart also must leave early. Can I request that they, if they can find it in their heart, to wait until we finish that which we did not finish in our last meeting? Thank you.
Let me assist you. That report is done, Honorable Masebo. We started with it. Done.
Oh.
Please go ahead with your question.
When I was
done. Thank you.
Let me come to the business of the now, Chairperson. I just want to take this opportunity, Chair, firstly to applaud the department for the work that they've done on this matter. And also in fact, for me, I don't want to go into the issues of procedure, because I know that the officials, I was once an official, sometimes in some other places, the officials, the senior management are very much reluctant to deal with such issues. Hence, we have this lot of corruption that is taking place in the department. So this work must be applauded, because it is not easy to hold your colleague accountable for wrongdoing, because of the history that I was exposed in. I think they must be applauded, and we are looking forward in more of such activities in order to clean the department. That department must be cleaned of wrong and undisciplined officials who cannot stay at work, who cannot do their work, who are really doing very bad acts of, you can imagine how we have always been concerned about the drugs and asking ourselves, how do these drugs come in? How sometimes in some other facilities where security is tight, you find that the prisoner escaped. So these are the things that even the community themselves were worried exactly what is happening. Now today, this report has given us, an insight as to these things are done by these officials. Hence, I'm saying they must be applauded. And from my side, I would urge the committee to accept this report and support it, because, Chair, we must help our department. And also on the issues that maybe would want a follow-up, I think, Chairperson, we are having a subcommittee, which is chaired by you. And you being there with our colleagues, we know that you are doing a good job. So other things, you will note them, and then you make a follow-up. So in short, Chairperson, I just want to say I applaud, and let's just appreciate and support our department further to continue dealing with these issues. Thank you, Chair.
Thank you, Honorable Jele. Commissioner, there were more comments made by Honorable Jele. If you want to respond to those and one or two questions, quick response to Honorable Jele on on her contribution.
Chair, we appreciate the comments made by Honorable Maseko Jele. Just to indicate, Chair, that what we are also doing is where there are these transgressions of ill discipline, specifically relating to the smuggling of contraband, we are also taking criminal actions against these officials now to ensure that we create the required deterrent on this, because the smuggling of contraband into our facilities doesn't only relate to the smuggling of contraband, but it impacts on the security and safety of our other officials as well as offenders. So we take the matter very, very seriously. Thank you, Chair.
Thank you. Honorable Self, it's your turn.
Thank you very much indeed, Chair. I have actually been covered by my colleague, Werner Horn.
Thank you very much, Honorable James Self. Honorable Msimang, are you there?
Sorry,
I am
Chair.
there, Honorable Chair.
Sorry,
And
Chair.
thank you for the opportunity.
Just hold, Honorable Msimang, just hold. Honorable Swart.
I didn't get a response, but mine were also mainly comments, and it was just, again, to my input, but just to ask the Commissioner if they could just look at that issue of coming back to us in writing about the pending matters. That was basically the only issue. But I joined the previous speaker in just commending the department in the approach. That was my input. Thank you, Chair.
My apology there, Honorable Swart. Honorable Msimang.
Thank you, Honorable Chair. I want to start by saying that a very strict disciplinary code is essential in the environment of correctional services. And therefore, one has to say that we commend the authorities for the work they are doing, especially if this is not just a sample, but it is all the cases that they are, because they spend a long period from 2007 till 2017, I think. But there are quite few. And I want to ask, why is it that the offending officials are always appealing against sentence, not judgment? It means they all admit that they are guilty, but they don't accept a harsh sentence. And therefore, another question is, are there alternative sentences, especially when one considers the weight of the offenses against the weight of the sanction? In many of the cases, I easily agree with the sanction, but for instance, when it comes to absenteeism, I would want to know, when does it become so serious that somebody has to be dismissed? Or is it 1 day, 1 week, 1 month? Are lesser sanctions not effective? And I'll end there. Thank you, Chair.
Thank you, Honorable Msimang. National Commission and your team to quickly respond to that, and also take into account some of the things Honorable Swart said, which I missed to take back to you. Thank you. Commissioner? National Commissioner, are you here?
Yes, we are here. It's Ms. Mawela from Delta ER. In relation to the question asked, we are saying yes. For Department of Correctional Services, we are dealing with trust relationship between an employer and an employee. When coming to the lesser sanctions, or we do have alternative sanction where we're looking at the seriousness of the matter. if the matter is less of serious, official are brought in for sanctions that are meted out in the disciplinary code. However, we do have the 3 months without the 3 months in alternative, 3 months without pay alternative to dismissals. So we look at the seriousness of their misconduct in what has committed by the the member. Sorry.
Okay.
Is the mic off there? Thank you, Chair. Can I just respond to Honorable Swart also?
Yeah.
With regard to the time frames, it would be difficult, Chairperson, because this relates to external role players. So it would be very difficult for the department to be able to attach time frames to those. Where it's within the department's purview, we'd be able to provide that. Thank you, Chair.
Okay, thank you very much. Let's go to the next speaker, Honorable Gladys Breitenbach. Honorable Breitenbach.
Sorry, trying to unmute a second. There we go. Okay. Thank you. I'm largely covered by the Honourable Horn, but I do have some questions about slide 17, please.
That's okay. Go ahead, Honorable Breitenbach, or you want them to show the slide?
No, it's not necessary.
Okay.
I'd like a little bit more information about that incident.
We caught you there. We caught you making coffee there, but go ahead.
No, I was actually reading through the slides and then I couldn't get back to the screenshot to unmute myself. I'd like a little bit more information, please, about this incident that you're talking about between 2 SMS members in the Western Cape Regional Office. It was initially investigated internally, and then an external advocate produced a report, and criminal charges were laid by both members and declined to prosecute in August 2019. So when did the incident take place? Who was involved, male or female? Were they suspended? Were they not suspended? And if so, for what length of time? What has now become of the matter? And if the decline to prosecute was already done in August 2019, why are we only hearing about it now? And I'd also like more detail about the criminal cases. Please, I'd like to follow up why there was a nollie prosecute in the matter. So I would require, please, the CAS numbers of the dockets and possibly the names of the complainants. Then there was just recently, last week or the week before, an incident at a prison in KZN, Westville, where inmates were allegedly assaulted by members of DCS. I did report it to the judge, to Judge Cameron, and he is busy with an investigation. But I would like to know how it's possible that an incident of such a nature can take place, and the person in charge of the prison, when they arrived to investigate, claims not to be aware of an incident of that nature taking place and not aware of any violence having been perpetrated. When I have the photographs of the results thereof, and it's very clear that inmates were in fact beaten up. So I'd like more information on that. I'd like to know what's being done about it right now, and how it is that the head of a prison doesn't know what's going on in his own prison. Thank you.
Thank you, Honorable Breitenbach. Commissioner and your team, response to those issues raised?
Thank you, Honorable Chairperson. My name is Peter Killam, Director Code Enforcement. I would like to respond to the first issue relating to the 2 SMS members in the Western Cape, to the Honorable member. On the first issue, the incident happened on the 1st of August 2019. It was a male and a female, both senior managers at the regional office. They were not suspended. Both of them were not suspended for the incident. And then what we need to remember is that the balance of proof in a criminal case and a disciplinary hearing is different. So we need to look at this on the balance of probability Hence, there was an internal investigation done by a deputy commissioner from the National Head Office, who then made a recommendation that an external investigator be appointed to maintain objectivity. That is how an advocate from Cape Town was appointed to do the investigation, and which made some findings, which is not finalized now, since the matter is with the National Commissioner and the executive for the decision making. I think I will leave it there. Oh, the cash number, the cash number, we will get that. We'll make sure that we provide it.
Mr. Chair, may I follow up on that, please?
No, not now, not now. Just wait, Honorable Glennis. Commissioner, I'll come back with follow-up.
Thank you, Chair. On the incident in KZN, I can provide feedback on that matter in writing, so that I'm just have the facts before me. Thank you, Chair.
Okay, thank you. Please hold on your follow-up, Honorable Breitenberg. Honorable Velma.
Yes, Chair. Thank you very much. Thank you very much, Chair, and good morning to everyone. Thank you for the presentation. Members have covered me on some other questions, but there is one question I'd like to add. For example, Honorable Maseko Chele raised in connection with the smuggling of drugs. I would like to know in particular what preventative measures have been put in place to curb the smuggling. We know that different kinds of drugs get smuggled in, and that's done by officials in some cases. So what are the preventative measures against that? And then Honorable Breitenberg has raised the matter in regards to Western Cape. Maybe I missed it, but what exactly happened? What is it? The other cases, you've listed what they did. It's in relation of smuggling, it's in relation of this. But the Western Cape incident, there's no information of what actually happened. And then thank you for the presentation. However, I still don't get the reasoning of why the department has been accused of abuse of power. I'm not getting that context. Yes, if it's wrongly, if the person is accused and a disciplinary hearing has to take place to establish, to establish the guilty or not guilty, but why is it that the topic is that the department is accused of abuse of power? And then, Chair, with just if you can, I just have to check the slide. I have a presentation that was given to us, I think it was in August, the 24th of August, and the topic or the title of that presentation was in DCS Gangsterism Management Strategy. We received the presentation, but that meeting was postponed, and so we never received the physical presentation. We only received the document. So, Chair, perhaps if you could advise that if we will still get the physical presentation, because I still have questions regarding that particular strategy. Thank you very much.
Meeting is still coming, so you can hold back on that. Thank you. Commissioner and your team.
Thank you, Chairperson. Peter Killian again. I just want to comment on the cash numbers. We did have it with us. If I can give the numbers, if that's okay. It's the first cash number is 8 of 829, and the police station is Goodwood. And the second cash number is 10 of 8/2019, and that's also Goodwood. And then maybe to respond to the second issue on the issue of detail, I think it would be unfair to the officials implicated as well as the National Commissioner to talk about that, because there is an investigation report now, and which needs to be considered. So if there's an outcome, I mean, it will be fair to share it then, but we have to also respect the two officials involved.
Okay. Fine.
Thank you, Chair. I was just wondering if you will allow us, when we deal with with security, even around the issue of the gang management strategy, that we then talk about the preventative measures, because it's an entire topic on its own, Chair. So to address it now, I may just be compromising that. And on the title of the presentation, I think the title was because it was the portfolio committee that requested us to respond to the issue. And that's why we've taken on the title. Thank you, Chair.
Okay, thank you. Before I come in with my contribution as a chair, any follow-up, Honorable Breitenbach, your last follow-up?
Thank you very much, Mr. Chair.
Honorable Vilma also has a follow-up.
Honorable Breitenbach.
Thank you, Mr. Chair. Yes, I'm still on slide 17, and I'm still very concerned about the lack of detail surrounding this incident. As the Honorable Niva Drachen pointed out, there's a lot of detail about all the other incidents, and about this one, everyone is stum. I'd like to read for the committee's benefit a newspaper report that appeared in City Press on the 26th of August 2019. This Women's Month kicked off on a bad note for Terry Nkandala, a female senior director in the Department of Correctional Services, who was allegedly throttled by her superior, Western Cape Deputy Regional Commissioner Freddie Engelbrecht, in his Cape Town office. Nkandala confirmed the attack and said she lodged a complaint. She's not allowed to comment further because policy does not allow it. Engelbrecht denied the allegations, saying he did not assault anybody. However, there were two witnesses to the incident, at least two witnesses to the incident, who say they found them in the office of Engelbrecht, and he had to be prized off of Nkandala, bearing in mind she's a woman, had to be prized off. He wouldn't let go of her throat, and only let go when the provincial commissioner, Delekile Klaas, came in and spoke to both of them. So, you know, you say you don't want to name them or shame them. They've already been named and shamed in the newspapers. This is a serious incident. Two senior officials, one a woman being assaulted, apparently, allegedly, by her superior. There are witnesses to this incident. It's more than a year ago, and still nothing is happening. And you tell me that a mere 3 weeks later, the NPA decided that there was no case. It takes the NPA sometimes 20 years to decide whether there's a case. In this one, they can decide immediately there's no case. So I'm going to be following up with the NPA about those two doctors. I'd like to see them, and I'd like to see on what basis they declined to prosecute. But I'd also like to know why this matter has been dragging on like this. It seems, on the face of it, on the reporting of it in the newspaper, that it's relatively cut and dried. I see nobody has sued the newspaper, so I must assume that what they've said is correct. And so stop being coy, please, and give us proper details and answer the questions. Don't hide behind protecting individuals and be coy about details. This committee has oversight over the department. This incident has taken place, and I'd like detail, please, and I'd like some answers, and I'd like them today.
Thank you, Honorable Breitenbach. Honorable Vilma. Your quick follow-up.
Thank you. Yes, thank you, Chair.
Yes.
The title is Abuse of Power, but in your presentation or in the topic, where or how was the department accused of abuse of power? So I just like that clarity. It doesn't come through. The abuse of power part does not come through clearly in the presentation we received. Thank you, Chair.
Thank you. Any other follow-up from any other member before the department responds to all of them?
Chair,
yes.
I think I would support Honorable Niholt, because I also wanted to find out exactly where is the abuse, because where I see now, where I am, it's like the officials are the ones who are abusing the systems of the department. So I think I would also support to if I can hear that, because where I am, there's no abuse.
Thank you. Any other member? None. Can I ask the commissioner and your team to respond to those 3 follow-ups, and then I'll come in.
Thank you, Chairperson. Peter Kilan again. I want to just go back to the issue of the Western Cape. We acknowledge that there was a newspaper report, but we are not sure where the sources of those newspaper reports is. What we do have in front of us is an independent investigation report, which will then provide details to the issue. I don't think we should compare a proper investigation report with a newspaper report, which is not based on the same set of facts. The actual case docket, I have a copy of the front of the case docket, which we can make available, but I'm sure the honourable member would like to get the full case docket from NPA. I want to just reiterate again that the NPA, and I'm sure they will talk for themselves, look at the issue of on a different balance of probabilities, which the DCS in a disciplinary hearing looks on the balance of probabilities only, the balance of proof. So we're looking at this in a quite different manner, and I'm sure there should be understanding for that. I just want to reiterate that we do take this matter very seriously. That's why the matter was referred for external investigation, so that a commissioner can have a proper information in front of him before he takes a final decision. Thank you, Chair.
Thank you, Chair. If I could add, it's just to indicate that the report is before me, and before we are able to decide on the action, with the delegations that we have, I have to consult with the executive. So that should happen within the next week. But what has been poor has been the long time that we've taken to resolve that matter, and I accept that. On the issue of the title, Chairperson, and the fact that we're trying to locate the abuse of power by the department, I think it was the registration of claims by these officials that the department has abused its authority, and that senior managers had been party to this abuse. So we were merely responding to the claims made by these individuals to the portfolio committee. That's my understanding. You may correct me if I'm wrong, Chairperson.
Okay, you done? You done, Commissioner?
I am Chairperson. Thank you.
Yeah, maybe at this point, just to come in, before we wrap up the situation, is first of all, the complaints were received by both the chairperson of the committee and the chair of the subcommittee, and upon receiving those, we wanted the department to come to us and explain. It's a dossier of issues, to come and explain what's happening around those. So that's the explanation that we are responding to what has been complained as abuse of power by the complainants. That's the first point. The second point, Commissioner, is it's 2020 now. Many of these cases are pending as far back as 2014. So we're in a 6-year period of cases not solved. Coupled with that, suspensions for months. Now, in your response, it will be important that we get, as indicated earlier on, really the actual reasons why it has to take so long for cases to be concluded. But even more serious, I would want to know, when you have got such long cases and suspensions, can you quantify for us the amount in legal fees paid by the department in relation to these cases? Because this is not just the cases where there's no financial money involved. I'm interested to understand, because the issue of litigation against department is part of our program. as this, both the subcommittee and the main committee. So I'm interested about telling us the legal fees involved in this, how much you have paid for this process, and you still have got 5 pending around that. So, and then my next point, which you have responded to, and thank you for that partially, this issue of, because I just couldn't understand why an official would be found with Mendex, and yet is taken to a DC process. That's a criminal offense. Anybody found with a Mendex or cocaine, there's a very clear thing what happens. So whether you are an official, being found with the Mendex is not a DC matter. So I'm really curious to understand, and you've started to respond to that as the department, you're only starting to deal with that in that way. I also am further curious on this one. I'm just curious, maybe, and I need to share, because you just educate me on this issue. There, out of those 11, there are 2 cases of Mr. Moloto and I think the other one, both women, who had intimate relationship with the inmates. Now, I'm curious because I want to understand, because what is happening in these correctional services. The fact that you made that conclusion, please share for me to make me understand the examples. What made you to conclude that there are intimate relationship between an inmate and these 2? Because here these are the people who must lock inmates. So are you saying that before she locked an inmate, she kisses this inmate, or what is it that made you to conclude that there's intimate relationship? Does she bring flowers, gift to and this intimate? Because you have concluded the case, so you've found reasons to come to that point that the warder and an inmate, and I'm curious about what, otherwise you wouldn't found your case around those issues. What are these kind of preferences? Or this inmate is let out, go to the offices of this? What exactly are we talking about here? Please share that with us, because you've dealt with the case. I'm also not happy, and as for this, especially for the subcommittee, I don't want to accept if you send a presentation to us, I'm not going to accept a presentation a day before that is called amended presentation. Amended presentation are not acceptable. You send us one presentation, we study it, we go through it, because why would you have so many amended presentations? What is it that changes all the time around this? The deputy minister has made a very important remarks at the beginning, setting the tone about the need for us as a committee that we might need, given what we have asked right up from Mr. Horn and other members, who might need to want to process these matters further, respecting the processes that we have embarked on. So anything else you're going to give us is going to indicate, therefore, how far we take this. So can I just hear your response to that before I go to the Deputy Minister?
Thank you, Chairperson.
Sorry, Chair Wilma here. I just want to interject. And it's not even one day before. This morning, we received the amended presentation this morning.
That's what I'm addressing. Sorry about that. You didn't raise that. Please hold back. I'm attending to that. Honorable Commissioner.
Chairperson, I must apologize about the amended presentation, because and the officials will have to account, because it wasn't done with my endorsement. I had not indicated when I'd heard about the amended presentation, I directed that no amended presentation must be made. So I'm apologizing on behalf of the department, but I'm holding my officials accountable for amending something that had not cleared me, even if there were errors on the presentation. So I apologize, Chairperson, on that one. On your request in terms of suspension timelines and the quantification of the legal costs, Chairperson, I'd be able to provide that next week to the committee in writing. So if you allow me, I'll do that. Chairperson, on the matter of the smuggling of contraband, I need to indicate that we are in the process of assisting our officials in evidence collection, because I think what is critical when we deal with issues of criminality is the whole aspect of evidence collection, how we manage that. So there's a process that we're putting in place, but we have also got collaboration with local law enforcement. So in many instances, in recent times, we have ensured that law enforcement, even if we have information of an imminent transaction taking place within our facilities, we ensure that law enforcement is available to execute arrest of the officials. On the issue of intimate relations, it is a challenge within our within our facility. In some areas, it is where these female offenders have intimate relations, or officials. This is the officials have intimate relations with these offenders, and the risk of those where they have prolonged relationships. We've even had officials that when the offenders came out on parole, that they actually live together. So there's a number of these challenges that we are actually responding to. You must remember, some of the offenders in our facilities, Chairperson, are not impoverished people. They are not necessarily part of the marginalized within our community. And I think that is part of the challenge. So as a department, we are looking and reviewing some of our standard operating procedures so that we are able to detect some of these tendencies in advance. Because in our instance, any deviant behavior with offenders is a possible threat to life to a fellow official. And that's why we deal with this matter very seriously. So I don't know if I've covered the questions you've posed, Chairperson.
Deputy Minister.
Thank you very much, Chairperson and honorable members. First of all, I want to appreciate, as the National Commissioner has just done, the words of encouragement that have been given to the Portfolio Committee given by the Portfolio Committee to the department. We appreciate the support in terms of expression of the work that you are doing. We also appreciate the advices that continue to be given to us. We know that some of us realize the issues of concern that are being raised by the Portfolio Committee. And when they come from, in quotes, outside of the department, it does validate the concerns that we have as part of the department. Indeed, it's a concern for us as the ministry that some of these disciplinary cases take this long to be finalized. Of course, the easy target for that is lack of adequate human resources to attend to these matters. But also, of course, the other reason would be the involvement of external investigators or people presiding over the disciplinary actions, where you find that we have to balance our available time with the time available to the experts that we engage in order to ensure that there's impartiality and objectivity in the manner in which we handle these matters. Of course, that the information that has been requested, which we are not in a position to provide now, and the information that we promised to provide to you will be provided within the stipulated time. The Commissioner has said that, for instance, the report on the matter of the Western Cape is going to be, his response to that report will be available within a week, because he still has to consider its implications. That is the report. And of course, any other matter that you have. Well, I think I need to sort of explain the suggestion that I kind of made, which is up to the portfolio committee to take up or not, where I said that you might want to consider listening to the other side, that is the complainants. I think it's a matter of natural justice that if a person comes to you as an arbiter, complaining about somebody else, you ought to listen to that person as well. So far now, the portfolio committee has listened only to the side of the people against whom the complaints are made, that is the department. Now, several speakers or members have raised the question, why is this matter being referred to as the abuse of power by the officials? Of course, the department in its report has come up with a position that shows no evidence of abuse of power. The normal processes that are supposed to be followed have been followed according to the report, but these are officials of the department, officials who hold positions of responsibility, people who are supposed to know discipline, the code of conduct, and the manner in which abuse of this thing, of authority, is supposed to be handled. They still come to us as the ministry. They also come to you as parliament to say we have been subjected to these actions of discipline, to the levels that have been taken. But we maintain that this has been partly because of abuse of power. So, meaning therefore the abuse of process. So that it is on that context then that I'm saying, because a complaint has been presented to you, you are obliged to report back to the complainants as parliament on what you have done about the complaints that have been raised with you. And therefore, I imagine that it might be necessary for you to call on them to come and say, but this is the report we got. How can you say authority by officials have been abused when the due process has been followed? So I'm saying this, Chairperson, fully aware that I'm leading, together with the Minister, the Department of Correctional Services, and I'm supposed, and I'm on the side of the officials and the department. But the very fact that you are there to probe and monitor the work that you are doing and exercise oversight means that we all have to work together to assist each other to ensure that we run a Department of Correctional Services that is true to its mandate. A department that is part and parcel of the security cluster, which is there to ensure that there's peace, there is respect for human rights, both for offenders, citizens, as well as officials. So therefore, Comrade, I nearly said Comrade Chair, but that's an English term. We do appreciate the support you are giving us, even if you appear to be critical of what you are doing, so that we improve in the delivery of the service that we are supposed to deliver. Thank you very much.
Thank you, Honorable Deputy Minister. This is how at least I'd like to just sum it up as we conclude this, that we met on Wednesday. We ask you to provide us with information next week. Well, again, saying today, Friday, by the end of the week next week, all of the questions raised with details from Honorable Horn and all the other members, would want to have them next week, because that is going to enable us to then plan the proper next step. We're rising today, so when we come back in the next term, We want to have our program that attends to this, but therefore answering those questions is going to be important to assist us to develop that program. Honorable Maseko Jail has already charged the subcommittee to take these issues seriously as part of the program. So we take that responsibility. Hence, it's going to be important that we get that information. And quite clearly, today was a first step because we have asked the department to respond to queries and complaints that were submitted to the chair and the chair of the subcommittee. Now that done, we are, and subject to what you give us as from next week, if we have difficulty giving us everything next week, please, you will indicate that so that we kind of aware that the next step would be taking cue from the Deputy Minister that it is proper, because in any case, whatever presentation you would have made, we have to respond to people who complain to us. And so we're going to design that kind of a process. Some of the things that you have raised here, we're going to take them up as part of our program. My curiosity has not stopped, Commissioner. In your response, you have just said that, you have raised vulnerability of our officials. When you make the point that some of the inmates are inmates with money and wealthy, it then says to me, so in a way they buy their love. So in a way they use the resources they have to stay better in this. I'm very much curious, and we're going to have the proper oversight program and more details about that, because this might just be a tip of the iceberg that we're getting. So we're going to have to attend to that kind of level of vulnerability, because this speaks to ethics and the kind of discipline from officials. They need to be beyond reproach on any issues, whether it's material issues, it's money, or any other thing. So you've just opened that door, and I'm getting into that door. As part of what Namaseko Jela says, as a subcommittee, we have a work to do. So we really are going to have to package that and put it together to follow you. And some of them would have to be done through questions. So I want to thank you for that. On the issue of both amended presentation and any presentation where we have a timeline, we're not going to have a meeting when members are given a day or 2 days to read presentation. There will be no meeting, and I'm going to follow that up with something in writing formally to both the minister and deputy minister to indicate so that they understand our processes. That we need to allow these members to apply their mind on anything that must come in front of this committee. They can't be rushed to read something overnight, over 2 days, and so on. That one, there's no discussion about it. I want, with those words, colleagues, so that we get to the second presentation, to wrap the discussion up. Apologies for that.
You covered me.
Thank you.
You covered about the support of the listening of the.
Yes, thank you, Deputy Minister, and thank you, National Commissioner, for your presentation. I hope you, as you leave this meeting, you go straight into those issues that we must get next week. Thank you very much. You are excused. We are now going to get into our second presentation from the Department of Justice, and we're going to ask Mr. Roberts to lead us in the presentation on that. Thank you very much. Mr. Roberts, it is now your time to present.
Thank you, Mr. Chairperson. The bill that has been introduced is the Cannabis for Private Purposes Bill. It's Bill 19 of 2020. The bill was developed as a result of a Constitutional Court judgment. Before I actually deal with the judgment, I just want to point out, in terms of the international drug control regime, which South Africa ratified, namely the Single Convention on narcotic drugs as amended, the 1972 protocol, as well as other conventions. Cannabis is listed as a psychotropic substance amongst other substances that is peculiarly harmful to other persons. And the international drug control regime restrict the use of such substances to scientific or medical use. And the conventions or the drug control regime actually says that countries must criminalize certain conduct in respect of such substances, which will include cannabis. However, even in terms of the international drug control regime, the criminalization or South Africa's obligations in terms of that protocols is subject to our constitutional dispensation. In the matter of Prince, the Drug and Drug Trafficking Act, as well as the Medicines Act, certain provisions thereof were challenged on a constitutional basis. I'm only going to deal with the Drug and Drug Trafficking Act, and that deals with Section 4B, which deals with the possession and use of drugs, and 5B, that deals with dealing in drugs. And according to the Constitutional Court, those schedules or the prohibitions is unconstitutional due to the fact that it limits, or on an unconstitutional basis, limits the right to privacy of an adult person. The case was decided on the basis of the right to privacy, as is in the Bill of Rights. When the court declared the provisions unconstitutional, it suspended its declaration for unconstitutionality for a period of 24 months in order to give government chance to correct the constitutional defects in the Drug and Drug Trafficking Act. Next slide. And the interim relief that the court granted was to the effect that the clauses in questions was amended by a reading to the effect that adult person may for personal use be in possession and use cannabis in private for his or her personal consumption, and that the adult person may also cultivate cannabis in a private place for private purposes. The effect of this judgment is set out in paragraph 4. I discuss it. Is to the effect that the adult person may use and possess cannabis in private for his or her personal consumption. He may use, which includes smoking of cannabis, but an adult person may not smoke cannabis in public or in the presence of other non-consenting adult or a child. The use and possession of cannabis in private, other than by an adult for his or her personal consumption, is not permitted. Further, in terms of the judgment, the cultivation of cannabis by an adult person in a private place for his or her personal consumption in private is no longer a criminal offense. And the court then stipulates that in order to determine whether a person possesses it for his personal consumption, important factor that needs to be taken into account is the quantity of cannabis that is found in his or her possession. That mainly relates to the police that needs to enforce the de facto legal position that resulted from the Constitutional Court judgment. And that is the guidance that the Constitutional Court gave to them and say, if a person is in possession of a large amount of cannabis, it's probably not for personal consumption. Further, the court states that where a person is charged with the possession of cannabis, the onus is on the state to prove beyond reasonable doubt that possession of such cannabis is not for personal consumption. Important further remarks that the court made is discussed further in paragraph 5. First, obviously, it infringes the right to privacy. If a person uses cannabis for private purposes or cultivated for that purposes. And then the court further say cultivation of cannabis in private by an adult person for personal consumption in private should not be dealt with on the basis that a cultivation must be in a dwelling or a private dwelling. According to the court, it's possible for adult person to cultivate cannabis in a place other than his garden or a place where he resides. The only question to determine that is to determine whether the place where such cultivation takes place can be regarded as a private place. Regarding possible commercialization of cannabis, the court remarked that dealing in cannabis is a serious problem in this country, and the prohibition on dealing in cannabis is a justifiable limitation on the right to privacy. And the court remarked that it cannot decriminalize cannabis for the purpose of resale or cultivation for resale or commercialization. The court then restates that there's no persuasive reasons that was furnished to the court that the possession or use of cannabis should be restricted to a home or private dwelling. And according to the court, as long as the use and possession of cannabis is in private and not in public, and that the use and possession of cannabis is for personal consumption, the adult person is protected by the readings in that the court provided. And furthermore, important aspect that needs to be pointed out is that Parliament has the obligation to determine the permissible amount of cannabis that may be possessed by an adult person. In paragraph F on the slideshow, we're going to discuss it now, but important aspect that needs to be clarified is that this reading in, or rather the decriminalization of cannabis, only applies in respect of an adult and not a private, and not a child. So children, in terms of the Prince judgment, is excluded from the decriminalization of cannabis. This gave rise to the matter LM versus the Minister of Justice, which deal with children and cannabis. In that judgment, the court correctly remarked that the Prince judgment only relates to adults, and the fact that the use and possession of cannabis in respect of children is further criminalized amounts to a status offense. And according to the court, such a status offense is unconstitutional. The court also remarked in that judgment that the further criminalization of use and possession of small quantities of cannabis by a child cannot be saved by the limitations clause in section 36 of the Constitution, since there are other less restrictive means available to deal with drug abuse by children. In the judgment, reference were made to the Prevention and Treatment of Substance Abuse Act, was amongst other referred to. In the Allen judgment, the court also set out the international position in respect of children that use, or let's rather call it abuse, small quantities of drugs. And it was summarized to the effect that incarceration or the criminal justice system is not an appropriate mechanism to deal with children who commit minor drug offenses. And alternatives should rather be explored to deal with that. Further, the court also remarked with reference to section 28(1)(g) of the Constitution that criminalization or detention of a child is a measure of last resort, and it's probably not always appropriate with minor drug offenses. And then the courts also declared section 4B of the Drugs Act invalid to the extent that it further criminalized the use and possession of cannabis by a child. So in terms of the two judgments, the effect is that adult person may use and possess cannabis. Adult may cultivate cannabis plants in private for private purposes. And in terms of the Allen judgment, children cannot be found guilty of offense as contemplated in section 4B of the Drugs Act on the basis that they use or possess cannabis. The Cannabis Bill aims to address the two judgments. Of course, one deals with various definitions. I'm not going to discuss the whole bill in detail. There's a comprehensive memorandum of the objects that accompanies the bill, which summarize each and every clause, and which can be used as a full reference to what is catered for in the bill. But in general, the bill amends the Drugs Act first to remove restrictions on the commercial cultivation and production of hemp. Those provisions is contained in section 1.2 to the effect where it is stipulated that the provisions of this bill do not apply to a person who cultivates a cannabis product in terms of the authority of any other law. The effect thereof is if other laws is promoted to further regulate the cultivation or commercialization, that other legislation must authorize that, and the act will then, this bill will not be applicable to that conduct that is authorized in terms of the other law. Specifically with regarding to hemp, this has long been an issue which was discussed, namely that the cultivation of hemp may have substantial, or rather the potential to create substantial income for the country. Currently, in terms of the Drug and Drug Trafficking Act, the cultivation of hemp is prohibited due to the fact that in the schedules to the Drug Act, dagga is defined as any part of a cannabis plant, and that will include hemp. If you look at foreign jurisdictions, countries that allow the cultivation of hemp also promoted legislation to deal with such cultivation and processes through cultivation of hemp, or where hemp is then for commercial purposes further distributed. And look at countries like the United States of America, Canada, Australia, amongst others. I already explained that hemp cultivation must take place in terms of the authority of a law that must authorize that. In terms of the bill, in the absence of such legislation, large-scale cultivation and commercialization of hemp will contravene this act, since hemp is regarded as cannabis within the purview of the bill. This is mainly to address some concerns by the South African Police Service that hemp and other varieties of cannabis with a high content of THC actually look similar. It's difficult for them to distinguish between the two species or strains. It's my submission that authorization under other law is the first requirement that must be met before it can be commercialized. And the second one is obviously, if it's small quantities, it's further regulated in terms of the bill, since such a person will most probably not have authorization in terms of any other law. If you look at other countries deals with the regulation of cannabis, which has a high THC content, on the basis of regimes similar to that of tobacco or alcohol. This has, amongst others, been implemented in Canada, the United States of America, as well as Argentina. So that is the first part. The second part of the bill mainly addresses the impermissible constitutional limitations that resulted from Section 4B or 5B of the Drugs Act, and to make it in line with the right to privacy of an adult person to use and possess cannabis or cultivate cannabis plants for personal use. I'm not going to go into too much detail in the other sections, but this one is probably important. Person may for personal use possess unlimited cannabis plant cultivation material. Cannabis plant cultivation material is seeds and seedlings. Adult person may in private for personal use cultivate 4 cannabis plants per adult. And if it is a place where there is more than one adult, in other words, 2 or more, a restriction is placed that in that place, not more than 8 cannabis plants may be cultivated by the adults living there. Further provision is made that adult person may, in a public place, however in private, possess up to 100 grams of dried cannabis. Adult person may, in a private place, possess up to 600 grams cannabis. And again, if it's a place where more than one adult is present, all adults at that place may not possess more than 1,200 grams of dried cannabis. Provision is further made that an adult may, in a public place, again private, that means concealed from public view, possess one flowering cannabis plant. Clause 2 further makes provision for the distribution of cannabis and cannabis plant cultivation material between adults. Restrictions is, however, imposed to the effect that adult persons inter se may not distribute more than 30 seeds or seedlings amongst each others, not more than one flowering cannabis plant, and not more than 100 grams of dried cannabis. And clause 2 also recognize the right of adult person to smoke and consume cannabis. What is allowed in clause 2, is however subject to restrictions that is imposed elsewhere in the bill. And the aim of these restrictions is mainly to criminalize an adult that contravenes what he may possess or what he may cultivate or what he may distribute to other adult person. Clause 3 in this regard limit the number of cannabis plants that may be cultivated by an adult person and impose restrictions further on the cultivation on cannabis plants for private use. Clause 4 limits the quantity of cannabis that may be possessed by an adult person and also impose restrictions on the possession and storing of cannabis. Clause 5 criminalized the smoking of cannabis in a public place or in a private place in the presence of non-consenting adults or in the presence of a child. Further criminalize smoking of cannabis within a prescribed distance from a building where such cannabis smoke may cause a hindrance to other persons. Clause 6 impose certain, or rather make provision for certain offences which further protect children against the harms of cannabis. Amongst others, it criminalize the conduct of a person who uses a child to sell cannabis or cannabis products. It criminalize the dealing in cannabis where such dealing is takes place inter se between himself or a child. Further criminalize the fact that the child administers cannabis to a child. It also imposes obligations on the guardian or parent of a child and not to permit the child to smoke cannabis or cultivate cannabis plants, etc. Clause 7 provides for proportional sentences that a court may be imposed. I must point out that the serious offences is categorized as a category A offence, and a court can sentence a person for up to 15 years of imprisonment for category A offence. Under category A offences is classified amongst others dealing in cannabis or dealing in flowering cannabis plants. And most of the offences that is aimed to protect children against the harms of cannabis do qualify as Class A offences. Clause 8 of the bill provide for expungement of criminal records of persons who were previously convicted of the offence of use or possession of cannabis. However, dealing of cannabis or any other drug offence does not fall under Clause 8. It only specifically deals with use and possession of cannabis. Clause 9 of the bill further provides for regulations to be made, amongst others to regulate aspects which is provided for in the Act and which is necessary for the implementation of the Act. In the schedule to the Act, the Drug and Drug Trafficking Act is amended, and DAGA and tetrahydrocannabinol and dronabinol is removed from the schedule. And also amend the National Road Traffic Act to further regulate aspects relating to the consumption of THC insofar as it affects road traffic matters, amongst others, driving under the influence of THC or driving with above a prescribed content of THC in a person's blood is criminalized as well. Insofar it relates to the Cannabis Bill and children, I already referred to the Allen judgment. In the schedule to the bill, the Child Justice Act is also amended to ensure that level 1 divisions are applicable to less serious offences. That is mainly the offences where a child smoke or consume cannabis in contravention of clause 5, amongst others, that is smoke it in a public place. Other offences, amongst others, relate to the possession of cannabis in a public place that is not concealed from public view, etc. In terms of the bill, the previous convictions of children that were convicted of the use and possession of cannabis will also be expunged in terms of clause 8. Yeah, so that is more or less the basis how the bill deal with children. Various offences in the bill do provide that it can only be committed by adult person, thereby excluding children from the purview of the bill. Others, like dealing, is however applicable to both an adult as well as a child. And to an extent, it gives effect to the LM judgment in that a child is not treated differently from an adult person in terms of the bill. A further aspect that probably need to discuss is the constitutional deadline. We were given up till 17 September 2020 to address the unconstitutionality of the Drugs Act. And if we don't address it by 17 September of this year, the readings in will become final. You submitted that this bill will obviously not be passed by Parliament. The position or the legal position that further regulates a read in timelessly was dealt with in the various Ramovi judgments. And according to the Constitutional Court, the Constitutional Court then clarified the position and held that interim relief to address constitutional defective legislation, coupled with such a period of suspension, mainly have the effect that obviously if we don't promote the required amendments within the specified time period, the read-ins will further regulate the position. But there's no bar on Parliament to pass legislation after such a deadline to remedy the constitutional defective legislation. And in this case, the legal position will then be regulated by the Constitutional Court judgment until the bill is passed by Parliament. Thank you.
Thank you very much,
Mr. Chairperson.
Thank you. Thank you. That was a bit long, but necessary. Thank you very much for the presentation. I'm now just going to get straight into the discussion about it. I'm going to ask the following members to speak. Honorable Msimang will be the first, followed by Honorable Breitenbach, followed by Honorable Swart, if he's still okay with the connection, to be followed by Honorable Velma, Honorable Self, and Honorable Jele. Honorable Horn, I'm sure by now would have left us. Thank you. In that order, Honorable Msimang.
Sorry, Chair. May I ask if you've forgotten me? I've been here since the beginning of time. It was.
Thank you. I'll pass.
You'll pass. Okay, thank you. Honorable Glenis Breitenbach.
Thank you. I must say I'm quite astonished by this whole business. However, The Constitutional Court held that the permissible amount of cannabis that may be possessed must be determined by Parliament. I'm interested to know from Mr. Robertson, what basis did the department determine the amounts that have been legally prescribed for personal use? I've been trying to sit here and determine how much 25 grams of cannabis oil would be, and it appears to be a teaspoon or two. I'm not sure what anyone would do with that. I'm not familiar with the uses of cannabis oil, but a teaspoon or two doesn't appear to be a significant amount of any product. I presume it would require one to buy it 3 or 4 times a day. I don't know. How did they determine these amounts? I'm very interested to find out. And then clause 3.2 and clause 6.1b seem to be mutually destructive. If Mr. Roberts could help me there, please. Thank you.
Thank you, Honorable Breitenbach. Mr. Robertson, quick response. This is how we do it here.
Thank you, Mr. Chairperson.
You are alone. I don't see any other members, so you're going to have to fill in all the questions and respond.
Fine. Okay, in response to Ms. Breitenbach's question, first, how did we determine the amount? First, we don't deal with a teaspoon or two. Adult person may possess 600 grams of cannabis in a private place, or 100 grams of cannabis in a public place. The amounts is further regulated by a cannabis equivalent. One must remember, cannabis is not just leaves or flowers anymore. You can extract it and condense it up till a purity of, I believe, 98%. It looks like sugar. So it's further regulated by that. Regarding how did we come to this amount, legislation of other countries, amongst others, Canada, Argentina, various of the US states, amongst others, Alaska, California, Colorado, Maine, Oregon, Massachusetts, etc., were considered to determine appropriate amount. Practical realities were also taken into account. Obviously, if a person plants cannabis and he does so for private purposes, and he does that outdoors, he can probably only get cannabis once a year. So his 600 grams must last him till his next batch is ripe. A person that can obviously indoors hydroponically cultivate cannabis, and that will be more readily available. So my response there to is basically that we did consider foreign legislation. We did receive inputs from some people relating to that, the MPA, the police, that is quite knowledgeable on this, and we came up with that amount. However, it's for Parliament to change it. If they want to give adults more than that, it's fine. If they want to give them less, it's fine. It's in the hands of Parliament to amend that. Regarding the reference to clause 21B, sorry, I missed the other one.
It's, I have a follow-up, please, Mr. Chair, on the first question when it's my turn to follow up. I refer to clause 3.2, Mr. Robertson, and clause 6.1b appear to be mutually destructive. Please help me with that.
Thank you, Honorable Breitenbach.
Clause 2.1b.
No. Clause 3.2.
3. Clause 3.2.
And then clause 6.1b. They appear to be mutually destructive.
Okay. 3.2b.
Mr. Roberts, you must get a pencil and write this down. Clause 3.2. 3.2.
3.2b.
No.
That's
3.2. And clause 6.1b.
Okay, 3.2 deals with the obligation of an adult in a private place to take reasonable measures to deal with cannabis and ensures it's inaccessible to a child, cannabis plants. And then 6.1b relates to where a child is permitted or not, an adult is not permitted
to assist in the growing of cannabis plants.
but then there's an exception made that a child may assist such a person under his conditions, under his supervision with the cultivation of cannabis. To a large extent, yes, it is probably mutually destructive, but this was proposed on the basis that elder persons, to a large extent, some of them at least, use cannabis as for medicinal purposes, and sometimes they're quite sick, have cancer, etc., and they can probably not water the cannabis plants. But again, the obligation is on such a person or guardian of a child to supervise such a child when he tends to cannabis cultivation. So that was exclusion that were made on that basis.
Mr. Chair, when it's my turn, please, I will follow up on that.
Please hold back. I'll come back to you, Honorable Breitenbach. Mr. Robertson, please, if this is the pace we're going to go, we're going to have a difficulty. Have you done answering the questions? Because there are a lot more are coming, and you just need to take notes, proper notes, when the members are raising their issues. Are you done? Mr. Robertson?
Mr. Chairperson, I'm ready.
Okay.
Sorry, network problems.
Thank you. Honorable Swart?
Thank you, Chair. Thank you, Mr. Robertson. And I would appreciate the presentation. I also appreciate the researcher's documentation, Chair, which is very comprehensive, and one still needs to work through a lot of that. Clearly, this is very controversial. Many people will be very concerned about the court ruling and, of course, this bill, particularly communities that are ravaged by drugs, where marijuana is mixed with other drugs, mandrakes, and we see the impact of that on our communities. But we have a Constitutional Court judgment, and we have a bill before us, and we also have that Southern High Court judgment of LM, which you pointed out. And so we need to deal with the issue as public representatives. That having been said, I think it's very important for us to understand the difference between CBD and THC, which is your psychotic drug. Your CBD is a separate issue, and it's so cross-cutting, Chair. There's so many cross-cutting issues here. This is quite complex. And so just to better understand this issue, we have the medicinal usage, we have a commercial usage for hemp that was pointed out, which is for clothing, building materials, which is non-psychotic as I understand it, very low THC. And then you have the recreational usage, which is set out in this bill, which is the issue which is of the concern and which we will have a lot of public hearings and public submissions on. But my specific issues that I want to raise is the cross-cutting nature of this bill. And whether Mr. Robertson, and again, Chair, there are issues here that are cross-cutting, such as the impact on the Medicines and Related Substance Act, the issue relating to the Prevention and Treatment for Substance Abuse Act. There is a reference as well in the submission about hemp and an agricultural law. So there's an agricultural element that needs to come in here. Then, of course, we've got the Schools Act, we've got the road traffic ordinances, how this will impact as opposed to alcohol testing, how those type of implications. My specific issues that are coming, narrowing it down, given that input and given the Constitutional Court's guidance and the fact that it will be read in now from the 18th of September, that doesn't prevent us from amending, from passing this bill, is the following. much of the bill is going to be contained in regulations, Chair. And that is a concern to me, because firstly, the regulations are not going to be tabled in Parliament. We need to look to what degree we allow so much of the content of the bill to be guided by regulations. I'd like Mr. Robertson to comment on that. That's obviously where Parliament will come in. At the very least, regulations must be tabled in Parliament, but I would like greater certainty in the bill. Secondly, the penalty provisions. We would need to reconsider the penalty provisions. I'd ask Mr. Robertson, given the maximum of 15 years is almost similar to some categories of murder. And yes, we consider dealing very serious, but what guided the penalty provisions where mere possession could be in contravention of a regulation could result in quite a severe sentence. And we're aware of, according to some research, over 300,000 people have been arrested for possession of small quantities. And that's not condoning it, but I'm just saying the impact on the criminal justice system. Then we also need to understand the impact of the bill, given that in terms of the memorandum at the end, it says there'll be no financial impact. I think there's going to be an impact, and that's going to be on our police services, prosecutorial services, how they're going to distinguish between what is allowed, what is not allowed. So we're going to have extensive discussions, consultations with various agencies, with various law enforcement, including the medicinal side, because there clearly are some benefits, but there are also some very severe harms that can be caused. And I think that is how we, as members of Parliament, are going to have to balance the two and get a better understanding of the differences of CBD, medicinal solutions that can be, as was pointed out, where people have cancer, it can be helpful, but then against the ravages in our communities that is caused by marijuana and other drugs, and whether it's the criminal justice is best situated to deal with this, or like the Act of the Prevention and Treatment for Substance Abuse Act. So, Chair, those are some general comments. One or two questions that Mr. Robertson can briefly respond to, very briefly, given our time limits. We don't have to have long discussions.
Thank you very much, Honourable Swart. Mr. Robertson, response to that?
Thank you, Mr. Chairperson. The Department is well aware of the judgment of Smith versus the Minister of Justice. Obviously, regulations that will give rise to a criminal penalty amounts to plenary powers, and which is actually the work of Parliament. The regulations in terms that needs to be made in terms of this bill is mainly only relate to regulatory aspects. One amongst others is the prescribing how cannabis must be stored, how cannabis plants must be cultivated. The main criminalization or prescription is contained in the Act. It is correct that this position is going to impact on the criminal justice system, and I agree with Mr. Swart that extensive consultation must take place. I did try to explain the distinction between hemp and cannabis in the beginning of the presentation, and also what measures the bill provide to ensure that law enforcement is not hampered. If there's other legislation that authorize hemp, it must take place in terms of that legislation. And if you look at the legislation of other countries, it strictly regulates hemp cultivation from the seed until it ends up in a shirt. If a person doesn't have authority under such law, for purposes of this bill, hemp is regarded as cannabis and falls within the purview of this bill. It is correct that enforcement is a major problem. I'm going to make documents available to the committee, which actually discuss the various options that were considered, how it is implemented by other countries, as well as commercialization of THC-rich cannabis, which is in most other countries regulated on a basis similar to tobacco and alcohol. I think that is enough. Thank you.
Okay, Mr. Robertson, thank you. Valma, Honorable Devote, Drachen.
Yes, Chair, I'm here. Thank you very much, Chair. I didn't really have my hand up, but I will grab the opportunity as it presents itself. My concern, I did struggle with the presentation because the presentation that is on the screen is different to what we were emailed. So I really struggled to follow because there were differences. So I'd like the presentation that was shown on screen to be sent to the committee, please, because it really is different to what was in the email. So I couldn't really follow the presentation. Secondly, I think Honorable Swart has largely covered me in relation to the medicinal purposes and and the versus the drugs use and medicinal purposes for people with cancer, etc. So Honorable Swart has covered me in that aspect. And then my third point would be in terms of schools. Normally at high school, the high school children are, some of them already 18 years old and are still in school. Are they considered as adults already, even though they are still in school? And also, if this bill allows, certain amounts of cannabis in possession and for private purposes, and I'm already 18 years, but I'm in high school, do I still attend high school? Can I go into school with the cannabis on me? Considering also that some schools do spot checks for drugs. So then, if in that case, I have that amount of cannabis, which is allowed, I can use the law as my defense to say, well, it's for private use, it's the amount allowed for private use. And then, it could lead to drugs it would be a loophole for drugs to enter the school. So in terms of that, Mr. Robertson, if you could clarify that kind of situation, what would happen? And please do send the presentation that you've given today, because it's more, it has...
Thank you, Mr. Robertson. Quick one.
Thank you. According the Schools Act, a person that's over 18 at a school, if he possesses it at a school, will probably be regarded as an adult. And if he doesn't, if the cannabis is concealed from public view, he will probably fall under the provisions of the bill, the exemption. However, I think the Schools Act addresses this. The Schools Act actually, and the Child Justice Act actually gave rise to the LM judgment that you say that minor possession, or rather possession of a minor quantity of drugs, should not be criminalized. So the court, again, in the LM judgment, clarified the legal position in respect thereof. My submission is that the Schools Act must further regulate the situation. Also, Mr. Swart did point out various other legislation involved. It's correct. Other legislation must deal with the impact of the Constitutional Court judgment. The Act, or the bill, rather only gives effect to what needs to be done to amend the Drugs Act, and nothing further. Thank you.
Okay, thank you. Honorable Self. Honorable Self, if you're still with us. Okay, I proceed. Honorable Nomathemba Jele.
Thank you, Chair. I'm also covered in so many issues, but only one issue that I wanted to raise. It was about my concern on the time frame as to around the passing of this bill, because already it's September now. But also, lastly, Chairperson, we grew up in our town, in our townships, where older people used to be against this Dacha issue. But and our parents used to say, when you take this thing, when you smoke it, it has an impact of making you like a mad person, and things that you are doing are not in line with things that we would consider normally as a community. So I can imagine if our, in line with what Honorable Verma raised on the school children age group. If it happens that this child is still 18 years, and then is still at the high school, and there are quite a number of them, and they are allowed, because we consider them as adults, they're 18 years, and then they start smoking at school. My consent might be in line with what we grew up, the notion that we grew up with, that makes people to go, like crazy, a little bit crazy. What's going to happen if they misbehave at school and blame it on it? I'm not sure if maybe I'd get an answer on that one, but because if there was a medical expert would tell us the truth of this myth, if it is. Thank you, Chair.
Thank you, Honorable Jele. Mr. Robertson.
Thank you, Mr. Chairperson. Sorry, I'm not the
Werk
expert on the effects of cannabis.
Go
Mr.
ahead.
Chairperson, can you hear me?
Go ahead, I can hear you.
Not the expert on the effect of cannabis, so I can probably not answer it to the full, but yes. There was a provision in the bill which the state law advisors to take out, to the effect that the Minister of Justice may prescribe certain areas where a person may not possess cannabis. So I think after extensive consultation with state law advisors, we couldn't come to agreement, and for the interim, we did agree that we can probably take it out, but it will again be put before the portfolio committee during the consideration of the bill. That should deal with, amongst others, school possession of cannabis. Thank you.
Thank you, Mr. Robertson. Honorable Yako, it's now your turn. Honorable Yoli Soyako. Honorable Yako.
I'm so sorry, Chair. I think my connection was a bit bad. I think my comment for now will be very, very lay.
Before you proceed, there's a bit of an echo. Just switch off other things that are there so that we can hear you properly.
I don't have anything on now. Can you hear me?
Can hear you, but there's more noise. Go ahead.
Oh, okay. Basically, I just think that when we formulate bills, it's important that departments tend to put themselves in the shoes of the people that will use those bills, or will use them as reference in terms of criminal action. And I tend to agree with Honorable Breitenbach when she says, Glenis Breitenbach, when she asks about the quantity of use in terms of the cannabis. That means that I don't think that whoever is formulating the bill understands how it's used recreationally, how it's used medicinally, and how it's used otherwise. And obviously, we support a bill that legalizes the use of cannabis. However, I'm just wondering, what is there any public participation that has happened in the path to approving this bill? And just like the other honorable who just spoke now, I want to know what is the timeline as to how we're going to make sure that it's approved from the time now to when it's approved. I don't know if you can hear me, Jay.
Yes, thank you. I did hear you, disturbed by the noise there, but we did hear you. Honorable Robertson.
Thank you, Mr. Chairperson. Timelines, I did explain it in the beginning, so we're going to miss the timeline, but that a constitutional court judgment for the interim will cater for that. Regarding the amounts, I already explained that. We considered legislation of the various other countries and came up with an amount. We were also advised by members of the South African Police Service. The bill was unfortunately not out for public consent, and I know it was in already long delay. The main problem was that I don't think a policy decision was taken regarding the commercialization of cannabis. But we are under obligation to give effect to the Constitutional Court judgment, so this bill only deals with that. The Department of Agriculture is in the process of promoting legislation. I was informed that deals with commercialization of hemp, but no other government department has yet considered commercialization of high THC cannabis. Thank you.
Thank you. Honorable Breitenbach, your quick follow-up and others before I wrap up.
Thank you very much, Mr. Chair. In retrospect, I think I'll take it up with Mr. Robertson offline. I'd like to have a look at the various matters that are considered in arriving at the amounts. So I'm sure he'll be happy to share with me the legislation that I did look at from all those various places that he did mention. And then, Mr. Roberts, you mentioned that you consulted with some people. I'd like to know who some people are. You said the police and you said the NPA. Some people, I'd like to know who the some people are and if it's possible to know what their inputs were, but I'm happy to take it up with you offline. Thank you, Mr. Chair.
Thank you very much, Honorable Breitenbach. Any other member for a follow-up? Quick follow-up? None? Thank you. Mr. Robertson? Your last comment?
Mr. Chairperson, I'm going to make all the documents available. Okay, I'm going to make all the documents available regarding the background that were considered in coming up with this bill. It, amongst others, deal with the position of other countries, the various forms of cannabis regulation that were considered, as well as the advantages and disadvantages of each other. I'm also going to make available extracts from legal opinions from the department, that of Oxla and that of the DIRCO, Directorate International Relationships, which deals with our convention obligations mainly. So we even went that far to see what can be implemented and what must be done to fall within the boundaries of our convention obligations. I'll make everything available. Thank you.
Thank you very much, honorable members. Just as a summary, I think the following 4 points are going to be key. One, I think Honorable Swartz has raised the issues around the uniqueness that you're going to have more issues coming out of regulations beyond us approving this. So we're going to have to attend to that kind of balance. That's the first point. Two, now that it has come to this committee, we're going to have to design a process for public comments, which will also lead into your public hearings. Three, this is one bill that is not just driven by a single committee or department. There's going to have to be a program of collaboration with other departments that are relevant to this. In this case, your trade and industry has got a particular interest, your health department. So we're going to have to look into that. It's not just a justice driven kind of a process. We're going to have to think about that and see how we collaborate with those kind of portfolio committees. Members have raised a lot of things that are still unclear that would need to be clarified, including the use of it, issues of quantity, and so on, and as well as the kind of questions I think Clarity Valma was looking for. So at this point, I think we're going to pause there for this discussion, but as the committee, that's going to have to be part of our way forward as to how we attend to this. And I was highlighting that deliberately so that we would know that when we come back, we're going to have work. There's a reading clause here, which therefore attends to the issue of your timeline. So that does assist. So that's really my quick summary, colleagues, about this discussion. And there being no other item, committee, that was our last item, indeed. Do you confirm? And this is our last committee meeting as we go for recess. When you come back, you would come back with a program that takes into account a lot of some of these issues, end September, early October. We have got a lot of work ahead of us. As this department, we have 3 bills that we dealt with this week. Your related sexual offences bills, those 3 bills. You have this. We possibly have coming to us the correctional services one. So it's going to be heavy, let alone dealing with your annual report issues and all other items in our program. We are going to require that we stay focused in order for us to get the work done. Just the last point, Honorable Zalma and others, if you are coming to meetings that I chair, I move from the premise that any member who comes to that meeting has got to be given an opportunity to speak. So when I call upon a list, I call all the members because I'm assuming that people are coming to meetings ready. So I allow people to put it on record that no, I have got nothing to say. But I don't depend on whether you raise your hand or not. I call you up because you came for duty. Thank you, members. At that point, this meeting is adjourned. Enjoy your constituency period. Thank you very much.
Thank you, Chair. Thank you, Chair. So well. Appreciate it.
Thank you.
Thank you. Thank you. Thank you, members.
Okay. Umubi kakhulu ngoba usibiza noma singashongo ukuthi sifuna ukukhuluma. Bye bye.